The gentleman from Kentucky, my friend Mr. Barr, for 3 minutes.
Gentleman is recognized for 3 minutes.
I thank the chairman for his leadership on this issue, and Mr. Speaker, I stand in front of you today to support my friend and colleague from Nebraska, Mr. Flood, and his CRA resolution to nullify the SEC Staff Accounting Bulletin number 121, which would eviscerate financial institutions' ability to provide custodial services for digital asset firms. In theory, under SAB 121, a bank could custody digital assets. However, the conditions set forth by SAB 121 make it impractical for any bank. This very fact has been noted by Federal Reserve Board Chair Powell, who acknowledged it shifts away from the traditional custodial practices as custodial assets receive off-balance sheet accounting treatment. SAB 121 overturns decades of precedent regarding the accounting treatment of custodial assets for banks. If a bank decides to custody digital assets and adhere to SAB 121, the on-balance sheet requirement would have significant capital, liquidity, and other prudential consequences. This makes it difficult at best for regulated institutions to safeguard digital assets. The fact is, the technological, legal, and regulatory risks cited in SAB 121 are already addressed by the legal and regulatory framework that applies to banks' custodial activities. Yet SAB 121 did not account for that. Moreover, and disturbingly, the SEC did not consult with any of the prudential regulators before issuing this flawed guidance. Unfortunately, the failure to consult the regulators overseeing institutions that are largely impacted by an SEC proposal has become quite common under Chair Gensler. The SEC does not have the expertise to assess the same risks as the prudential regulators, and it is not the role of Gary Gensler to propose misguided rulemakings and guidance that may have major adverse implications to the functioning of our financial institutions and ultimately to the safety and soundness of our financial system. Given the implications for financial institutions' ability to safeguard assets under this rule and the clear lack of understanding regarding their prudential standards and guidance from their primary regulators, this rule is fatally flawed. The fact of the matter is, to the extent there is concern about a lack of regulation, if there's concern about a lack of regulatory clarity or risk with crypto, then we should not make it impossible as a practical matter for well-regulated banks to protect Americans who own digital assets with custody services. If you want to protect customers, if you want to protect investors in digital assets, then we shouldn't be pushing crypto transactions into less transparent, more opaque, riskier offshore places, but that's exactly what SAB 121 would do. And I have to address this issue of Silicon Valley Bank. Silicon Valley Bank's failure had to do with deposit concentration risk and interest rate mismanagement. It had nothing to do with the fact that many of its customers were technology firms or worked in the blockchain space. Had nothing to do with that. That is a red herring. And this is why I support Mr. Flood's measure, and I support the bipartisan work, and I encourage my colleagues to support it as well.
I yield my colleague 30 more seconds.
Gentleman's recognized for additional 30 seconds.
I thank the gentleman for yielding because as I conclude, Mr. Speaker, I would ask unanimous consent to insert 3 letters into the record. A letter dated March 2nd, 2023, co-signed by Chairman McHenry and Senator Lummis, sent to the Fed, OCC, FDIC, and NCUA, asking them about SAB 121's impact on regulated entities, and also asking if they were consulted prior to SAB 121's issuance. A letter dated April 6th, 2023, sent by OCC Acting Comptroller Sue to Chairman McHenry and Senator Lummis in response to their March 2nd letter, and a letter dated March 16th sent by NCUA Chairman Harper to Chairman McHenry and Senator Lummis in response to their March 2nd letter.
All letters accepted without objection.
I thank the Speaker, and with that, I will yield.
Gentleman yields back. Gentleman